the first to know Nsem-Pii TV.
Enra and John Dramani Mahama and Namni spokesperson Yera Felix Ofosukwache so at the krata ebeto abonten say was suspended Chief Justice no nyina petition mako miensa John Dramani Mahama said nsa aka a one say yenyi Chief Justice and I say akunya a meno eka say the ono so etimi e petition no ekoko pie mu ewo Council of State Council of State nso e de won afutuo aba eno na John Dramani Mahama say ogina so a was suspended Chief Justice near Bekaya petition no John Dramani Mahama timidi koma Council of State no ebi eba beto abontin ye kan NDC amanyuko ne se enya no kre enra Sami Nsem-Pii ekoko pie mu Asempa FM eko confirm se eyampa ni nyina ene se NDC amanyuko no ekire se Chief Justice etimi akwa spend sika 261,890 Ghana cedi from public funds eno ne private foreign travel oni ni kunu ene no ema na ewiase de mpanifo se utines wan kasem yeyu eyibone Chief Justice etimi ababonten ababe respond NDC amanyuko no Sami Nsem-Pii Felix Ofosukwache ene John Dramani Mahama nyina wetimi ababe reply omo na edie ntibetire na Chief Justice etimi ede eba na ode yenko na yenko tie Chief Justice ntibetire no osi Chief Justice Gertrude Araba Isaba Tokono has justified her decision to travel on holiday with her spouse and daughter at the state expenses. In her response to petition lodged for her removal from office, the Chief Justice denied allegation of misappropriating 261,890 Ghana cedi of public funds for private foreign travel with her husband and daughter. According to the Chief Justice, who has been suspended by the President following the establishment of a prima facie case against her, they claim that her spouse and daughter were not entitled to have their travel funded by the judicial service is untruthful and unfortunate within the context of her appointment letter and the judicial service foreign travel policy. And the Chief Justice HS and Sema NDC amanyoko ni de tu ni sunyina enu ade se nukure bia ewo memu akwantuo na otui ene Nigeria ene ne ma no eya ade se etini ewo judicial service appointment no ayede ma no na dewa NDC amanyoko ni ha won anika te se the Chief Justice akwa no abusuafo enye asemkotoa. Also, my appointment letter, which could have been included in the original bundle as Exhibit D01, clearly outlined the terms of my appointment as Chief Justice. These terms include 2 round-trip tickets for official vacation, each capped at the maximum of 14 days. Paragraph B1 of the appointment letter specified that travel expenses, hotel accommodation, and per diem for these holidays are to be borne by the judicial service. She noted in her response, enti osesa ekawe nyina yade se on appointment him say Chief Justice in year bia obetimi akodi holidays twice ewo amanoni ne ebia was spending days kra enu etimi ewo soro no 14 days. Enti onim de enti a NDC amanyuko no asaba abegina ha kase wakwa spend oman sika ewabre one appointment in spending we nyina judiciary no na ebe spend enti problem NDC amanyuko no ewo NSA. She emphasized that the judicial service policy on foreign travel, among other things, permit a Chief Justice to undertake unlimited official travels with his or her spouse or either person of his or her choice in a year, fully funded by the judicial service. Enti ose ya wone krata ni sem fumso bia enim se ono etu kwan obetimi ede ne kun aka ho anampo se nipa bi ope na asem anase ne ma etimi aka ho so onim de enti stella NDC amanyoko ne da so was stands no one person oyi ni free wonti no one efa se nyansa kwa we so It also states that when accompanied by the spouse or other person, he or she shall travel on the same class of air ticket as the Chief Justice and shall be paid the equivalent of half the per diem paid to the Chief Justice. These policies in place since 2010 explicitly authorize me to travel with my spouse or another designated person, such as my daughter, on official vacation. She urged that the decision to allow the judicial service to cover the expenses of her spouse and daughter was an exercise of her authorization granted by the policy on foreign travel by head of the Judicial and Superior Court judges and amended in 2019. And Chief Justice said, "Sir, travel expenses in yende ene ba be hyase ewo ho ate a enya asem ko 21 tiase die ntia ene ena NDC amanyuko nse one age na ho de shine na asia konwa ewa bra ada Chief Justices na besin ko obia eye binti aden enti na do Chief Justice we nko aso de ye ne te se de ase ebi NC da." Exhibit D04 is a response provided by the Judicial Secretary to audited seeking clarification on the expenditure for ticket purchase for my husband and daughter during my 2 holidays in 2023. Page 1 of Exhibit D04 confirmed that I opted to utilize the authorization in paragraph 9 and 10 of the travel policy to travel with my spouse on one occasion and my daughter on the second, in full compliance with my appointment terms. The Judicial Secretary responds to Observation 1 and Observation 2 in the Exhibit D04 further explain the expenditure, refuting the petition claim of misappropriation. And the Chief Justice afei ena wo kyerɛkyerɛ mu ye na obia ete ase se ade no ewo mra kwa so nti sa petition no kra won ede bai no enya ade se nyina so ana hoden evidence papa bia etimi ewom. Reported account of the petition against the Chief Justice indicate an allegation of illegal payment of per diem and purchase of travel ticket for her relative. However, Justice Tokono argued in her response that she was not responsible for the purchase of flight ticket or payment of per diem for herself and individuals who travel with her. I wish to emphasize that as Chief Justice, I neither purchased travel ticket nor determined the per diem issued to me or my accompanying aide, security, or designated person. These are administered by the Judicial Secretary and the Director of Finance of the Judicial Service in accordance with rate set by the Article 71 Committee on Emolument. I am not a signatory to any account and am therefore incapable of personally misappropriating public funds related to travel or per diem. She further denied failing to retire an amount of $9,589 being the balance of an impress issue for her travel. The petitioner claims that I failed to retire impress is untrue. I have attached evidence signed by me and collaborated by the Judicial Secretary showing that I spent $4,411 out of an impress of $14,000 and retired the entirety of the remaining amount 2 days after returning from my journey. This documentation refutes the allegation and demonstration adherence to financial accountability standard. The Chief Justice maintained that her travel with her spouse and daughter during her official vacation is supported by the privileges and obligations outlined in her appointment letter and the Judicial Service travel policy. These are standard entitlements for the Chief Justice akin to those provided to other heads of government such as the President or Speaker, Parliament under Article 57 Clause 2 of the 1992 Constitution. Can it be suggested by any stretch or the imagination that when the Chief Justice travel with a designated companion as per policy, This constitutes misconduct warranting removal from office. Would Ghanaians accept that the president or the speaker misappropriated state funds by traveling with their spouse or child on official vacation provided by their terms of appointment? Such a proposition would undermine the principle of our democracy and the meaning of misappropriation. According to the Chief Justice, it would be absurd to claim that she has misappropriated funds when judicial service policy implementers are responsible for the purchase of flight ticket and payment of per diems for her official vacation. It is my firm belief that the nation would find the petition allegation that the described act constitutes wrongdoing unthinkable. These claims are not only baseless but only misrepresent the policies and procedures of the judicial service. I respectfully urge His Excellency the President and the eminent members of the Council of State to dismiss this allegation, as they do not warrant further consideration. The evidence provided, including Exhibit DO1, DO2, DO3, and DO4, clearly demonstrate my compliance with all applicable policies and refute the petitioner's claims. Her response concluded, Chief Justice etimi abetrechre asemi nyina mu na NDC amanyukuo ne de nyankopon enkwa ene nokwafo.
Is yet to be heard. We know that it was rescheduled for the 6th of May. He's amended the process. He says the president has exhibited bad faith in the process of the removal of the Chief Justice. That's what he said. And we're asking why. He says, 1, the president initially exhibited an intention not to hear the CJ before the establishment of a prima facie case. This was further buttressed when the AG made the case that there is no law or case that mandated the president to give the Chief Justice a fair hearing before establishing a prima facie case against the Chief Justice. Now, this is the matter that's before the court right now. So, as you know, this is the matter I was talking about that the judge didn't sit, etc. The matter has been rescheduled for the 6th of May. That's when it will be heard. But the MP, the Member of Parliament, has amended his rate based on everything that is happening. He's asking the Supreme Court to consider these. That 1, the President of Ghana, John Dramani Mahama, initially exhibited an intention not to hear the Chief Justice before the establishment of a prima facie case. This was further buttressed when the Attorney General made the case, an Attorney General made the case in writing, that there is no law or case that mandates the president to hear the CJ. And many lawyers were concerned about that because one of the fundamental rules of procedure is all the autem partem rule, which is to hear the other side. He thought that was very basic. But anyway, that's what the Attorney General said to court. The court is here to hear these matters. So this is the amended rate. It says also that the president received the petition in February 2024 and waited till the end of March to disclose the receipt of the petition. All this was while he was undertaking consultations, which consultations were not exposed to the public. Okay, so they said the president got the thing in February, he kept it, suggesting that he had no intentions of giving it to the Chief Justice until the writ was filed and the Chief Justice wrote to him about it. All right. The other one is that the president, John Dramani Mahama, and his party faithful who occupy positions of power today, to wit, Mustafa Bande, who is the Deputy Operations Director at the Presidency, and Asiedun Katia, who is a member of the Parliamentary Services Commission and the chairman of the party, have showed an intention to remove the Chief Justice already. So in their writ, they detail some of these things like that Asiedun Katia said this, Mustafa Bande said this, Felix Kwachu Fosu said this. We don't have too much time to go into that. I'm just suggesting to you that there has been amendment of the writ by Mr. Asifo, the Honorable Member of Parliament. At 20 minutes to 11, let's get on to the interview right now with Lawyer Bafo. Yes, Bafo, you said you wanted to start from Abraham Lincoln.
You see, Abraham Lincoln in his Gettysburg Address said something which I think is very useful for us to do. I'll read a part of it which I think is relevant. He says that it is rather for us to be here dedicated to the great task remaining before us, that from these honored dead, we take increased devotion to that cause for which they gave the last full measure of devotion. That we here highly resolve that these dead shall not have died in vain. That this nation under God shall have a new birth of freedom, and that government of the people, by the people, for the people, shall not perish from the earth. You know, in 1992, when we committed to democracy, we did not commit to having the semblance of democracy. We committed to having a true democracy.
Okay, but let me ask you, what is wrong with what has happened? Article 146 says that if somebody wants to, is unhappy with the Chief Justice, a Ghanaian, you can petition the President. When the President is petitioned, he consults the Council of State. Yes, he showed the letter to the Chief Justice. Council of State have looked at it. We are not seized with, I don't know whether you have the full petition, but Council of State has looked at it, and they say that, hey, wait a minute, the Chief Justice has a question to answer.
Well, I'll tell you what is wrong with it.
Yeah, the President has the power
What
then
has
to suspend the
happened
Chief
today
Justice. Yes.
cannot be isolated from a certain background. The background of Mr. Esiedun Ketie's statement, public statement on various radio stations.
Before the election.
Before the elections and even after the elections, as recently as last week or last 2 weeks, that they were fully committed to removing the Chief Justice, and that they will remove all the members or the leadership of the Electoral Commission. Mustafa Gbande had also made a similar statement, if not the same. And so you cannot isolate that. These are the embodiment of the NDC.
That's the Mustafa Gbande statement they put on the TV.
That's right.
Yeah.
The embodiment of the NDC. So it is difficult to look at what has happened as something which is in good faith. But I read the statement to remind us where we are coming from. You see, we've run into a situation where we want to politicize everything in this country. And the middle institution, the institution that finds itself in the middle, we want to also politicize it. But what most Ghanaians don't realize is that, as they say in Chi, is the grass that suffers. And so what we, the political actors, are doing now, right? Yes, we may be unhappy because we are guided by where we are coming from. But ultimately, who is going to suffer is the ordinary Ghanaian.
Why would ordinary Ghanaians suffer? If the government of the day have the Chief Justice they want, why is the ordinary Ghanaian
If you politicize the judiciary, there is going to be fear, right? A judge sitting on a matter between yourself and perhaps a friend of a big man, or a relative of a big man might be intimidated.
He'll be afraid.
Will be afraid, yes.
To pass justice.
To pass justice.
Because he'll be sacked.
Because, yes, he can be sacked.
Because the Chief Justice is looking at him upstairs. It's part of the umbrella.
Exactly.
Okay, that said, what is wrong with this process?
There's several things that are wrong. Let's first look at Article 146 of the Constitution. Article 146(1) of the Constitution, which makes provision for the power, right, to initiate the removal processes, states that the President, the Chief Justice may be removed for stated misbehavior, incompetence, and infirmity of mind. What is stated misbehavior?
Something that has manifestly been done.
By what? What is it? What is the standard for determining stated misbehavior? There is no legal definition for stated misbehavior. Check. When you look at Ejechum versus Attorney General, it didn't define stated misbehavior.
But the petition was entertained.
Ejechum versus Attorney General considered whether, right, there was the need to determine, right, a prima facie case in the case of the Chief Justice.
Yes, correct.
It didn't consider Article 146(1). So as we sit here, what constitutes stated misbehavior? What goes into stated misbehavior? We don't know.
How can we not know? Misbehavior.
Stated.
If I sit here and I take the water and I'm pouring it on myself, and it's not because Black Stars have won a game, I'm just doing that.
That's
misbehavior.
And so you can remove a Chief Justice because of that.
No, not because of this. I'm saying that the Chief Justice does. That's why the petitioner must allege what the Chief Justice has done.
Paul, you see, not every offense will amount to a stated misbehavior.
I agree with that.
Exactly. And so, if you look at the whole gamut of Article 146, I stated it the other time, the interpretation of it is still evolving. And so, Ejechum concentrated on the need for prima facie case, right? what do you call it? Dairy versus Attorney General also considered whether or not, right, the publication of aspects of the petition made it unconstitutional, right? And then went on to say obiter, that in fact the comments of the Chief Justice may be necessary prior to the determination of a prima facie case.
So what's wrong with what has happened?
What is wrong is that there is the need for a regulation, even if you look at Article 14610.
Do you mean the suspension?
The suspension.
Or the prima facie, or
even
the process?
The whole process.
So what is the cure for a Chief Justice who is grossly misbehaving? What's the cure for it under the Constitution?
So the Constitution has made its provisions. To operationalize it, you need a regulations. And I will explain to you why you need a regulations. Paul, one, as I said, stated misbehavior is not defined. If you want to look at it even from the perspective of an employee-employer relationship, right? What may be considered misconduct is what misconduct is omnibus. The elements of it are always defined. In this particular case, what goes into the consideration of a stated misbehavior?
Well, but audit reports, etc., etc. You can find. I mean, those things are there.
Yes.
So the judiciary is audited.
Yes. And so the Chief Justice, right? The Chief Justice goes into this whole proceedings, okay, wondering whether the offense or the accusation made against her will meet the threshold of stated misbehavior.
Yes.
That is what you do,
Yes.
right?
Yes.
And that becomes, it becomes speculative.
Yes.
But the law is such that before you are tried for an offense,